a special resolution. So if you are a 75% owner, the balance 25%, 75% of that 25% will need to approve that related party contract. Now again, I made a broad theme about the difference between fiscal statute and regulatory provisions. So if you say, yeah, this is a contract that's not with the shareholder, it's a contract with an affiliate of the shareholder, he doesn't hold shares, so he's not voting, all other shareholders are voting. In my view, that would be illegal, and therefore it would be struck down by a court for the asking, because the intent of the legislation is not to take out a specific shareholder, but to take out that shareholder who's affiliated to that related party, because of which that party became a related party. Right? So the affiliated shareholder will have to refrain from voting. Now what does this mean for a wholly owned subsidiary? Right? Then the only shareholder is one, and you have a contract with a related party. So who votes on it? And what if you can't say it's in a arm's length and in the ordinary course? Of course, by rules we are told that the parent company may pass a resolution of its shareholders, but that may be beneficial to the parent company rather than to the wholly owned subsidiary. Let's say there is a wholly owned subsidiary in India which anyway deals with transfer pricing rules under the tax law and has contracts with its foreign parent. How do you deal with that? Are we going to ask for a shareholder meeting in a foreign jurisdiction to approve it? These are issues that have emerged and will need to be grappled with. And speaking purely as a lawyer, I would be very wary of accepting a regime where rules are allowed to clarify or override what the law is. There is a specific provision called power to remove difficulties. And very extraordinarily, the Companies Act gives a 5-year period. You need to set the rules of the game. And when new rules of the games are set out, you give the legislator or the administrator of the law some time to remove difficulties. Normally, you use 2 years for the power to remove difficulties. This act gives 5 years to remove difficulties. So if things like this have to be done, in my view, it shouldn't come through the rules. It ought to come in exercise of the power to remove difficulties, and that's the only right way to do it, because nothing really gets tested unless it really ends up in a court of law where you're asking a judge to decide whether something is legitimate or not. The final aspect of what I've been asked to speak about is class action suits. I mean, much of the debate, apart from CSR, that you heard about the new company law, has been about class action suit. Like this law which is suddenly going to bring in US-style class action suits in India. Let me tell you that the Indian legal system always had class action suits. The Code of Civil Procedure always had class action suits. It's because our justice delivery system is broken that we rank 134 out of 135 countries in the world in the ease of doing business and enforcing contracts. So no matter what you write in the law, that's not going to change. But the Companies Act has gone a step further. It said we will create a new court system, and therefore there's the NCLT, which one of the speakers, Mr. Dar, is going to speak about in this session. And you could move that tribunal with a class action proceeding. And there the provisions are pretty wide. You could act against the auditor, you could act against the director, you could act against experts who are named in the prospectus and seek damages. And the Act basically provides for thresholds and says that if you need at least 100 members, there's again a lot delegated to the rules, and the rules can determine whether these thresholds can be varied. But 100 members can get together and say that I subscribe to an IPO on the basis of a certain statement in that document. It is a misstatement, and I need to be compensated. And here's we as a class, 100 together represent all the members who have subscribed to the IPO and can move court. And if the tribunal were to rule in favor of those 100 persons, it's valid for all persons in the same class as they are placed in. So if or let's say if 10 people get together and get 10% and therefore are able to move the tribunal, that bunch of persons can represent the whole class of subscribers to that IPO and thereby trigger proceedings to seek damages and bring a civil action challenging, using the powers under the Act to get compensated. So this is something, again, that will get tested. The number of you who are from corporates, company secretaries, and professionals are going to have to deal with this. Those of you who are from investor interest groups, you have a new tool in your hands to take action. The other practitioners who appear have a new forum to argue in and deal with. But these are three broad areas which I thought I'll use from the, as I said, a rather eclectic subject to speak on that I thought I should give you a primer on. I'll be happy to take questions at the end of the session. So just to reiterate, shareholder agreements, restrictions on what you can do with your shares, completely legitimate. Even in listed companies, legitimate, subject to conditions being met. There are issues that I spoke about on related party transactions which have serious implications for wholly owned subsidiaries or even MNCs. A lot of times, even under the securities regulations, when you make an open offer, it is found, and again, there's no offense meant to any class of business people in this audience, very often you find that when a multinational company takes over a company, the response to the open offer tends to be sometimes high. At times it's driven by the price, at other times it's also driven by the belief in the market, in the capital markets, that transactions between the parent and the Indian listed subsidiary are now going to be technically compliant with transfer pricing laws and no more. And therefore, if you could get a better value from another customer, you're not going to be dealing with him, you're going to be dealing with your parent, which is a multinational, and giving it the best deal possible. So that is going to get materially affected by the related party framework, because the board, if it puts up its hand and says, this is on arm's length and this is perfectly in the ordinary course, it will be open to a class of people, for example, to use the class action suit and say, here are 5 other contracts by other peer companies in the industry. These are the terms they've got, and you favored your parent on a sweetheart deal. And therefore, this related party transaction ought to have been brought to shareholders. It was not, and therefore it's a fraud. And the earlier speaker spoke about the definition of fraud, and it's worth reading. And I would urge each of you to go back and just read the basic English in the law. No law is rocket science. The provision on fraud is like any provision on fraud can be, but the punishment for frauds involving public interest is like a minimum of 3 years and a maximum of 10 years. So what involves public interest, once you're a listed company, almost everything you do could be involving public interest. So any fraud alleged about you could be a fraud involving public interest. And if that's proven, and that can be proven not just in a criminal court, also in a civil tribunal, because there are civil liabilities as well in the tribunal and in the class action provisions that we just discussed. So these 3 broad themes, I think, have a central coordinating thread around them, that the cheese has moved and the way in which we are used to doing business is going to get materially affected. Thank you.